Guys, today we're stepping into a tense courtroom where emotions run high. The judge sets the stage for a dispute fueled by restraining orders, repeated violations, and claims of harassment. Both sides come prepared, but tension brews as everyone braces for confrontation. This isn't just legal procedure, it's personal conflict under oath.
You're here in the matter of Sarah Fazio versus Nevin Cooper Keel, case number 23-00563PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court this afternoon for the evidentiary hearing regarding an alleged violation of the court's personal protective order that was filed on or about June 10th of 2024. At this time, I'd invite Mr. Hengeveld. Would you like to place your appearance on the record?
Yes, good afternoon, Your Honor. I'm Jeff Hengeveld on behalf of Sarah Fazio.
Thank you. And Mr. Cooper Keel, would you please state and spell your full name for the record?
My name's Nevin Cooper Keel. First name spelled Nevin, last name Cooper-Keel.
Thank you, sir. And Mr. Hengeveld, this is your hearing on the alleged violation, so you may proceed.
Thank you, Your Honor. I have one witness to call, and that is Ms. Fazio. Ms. Fazio, can you please tell the court who you are?
My name is Sarah Fazio. My last name is spelled Fazio. I am the petitioner in this matter.
Okay, and are you a licensed attorney?
Yes, I am. I've been a licensed attorney for 24.
As the hearing unfolds, the petitioner lays out how years of unsettling emails led to the first protective order. The courtroom listens as she recalls the fear, the messages, and the strain of constant contact. The defense, however, questions intent. Was it harassment or misunderstanding? The judge watches carefully, already sensing this won't be a calm proceeding.
4 years.
All right, and how did you first come to know Mr. Cooper Keel?
I sent him a cease and desist letter on behalf of the client I think it was on June 23 of 2022.
Okay.
It was the first interaction I've ever had with him.
And in response to your cease and desist letter, what was Mr. Cooper Keel's reaction?
He sent me a series, several, I don't know if I have the exact count, of emails to my office email address that were a little unhinged and made little sense. I did respond to, I believe, the first one, if I recall correctly, instructing him not to contact my elderly client and to please direct future correspondence to me. He then proceeded to send me several threatening emails that he was going to sue me, he was going to sue my law firm. I ignored those to my best of my ability. And then he started up again in, I believe, January of 2022 or 23, I'm sorry. I started receiving a litany of additional emails that were more unhinged and more, that he was coming to my office and I was going to get something from him and that sort of thing. And that's when I initially filed for the PPO.
And under that PPO, the terms of the PPO, what is Mr. Cooper Keel prevented from doing as it relates to you and contact with you?
He is not to have any contact with me. He's not to reach out to me in any way. Not to send me things, come to my home, come to my office, appear within my site, that sort of thing.
Okay. And now we're here today on the motion to show cause for violation of the PPO, and I want to cover the factual basis for that motion. Were you represented by counsel in a lawsuit that Mr. Cooper Keel filed against you in Allegan County Circuit Court, that being case number 23-67017CZ?
Objection. Relevant.
Response on the relevance objection, Mr. Hengeveld.
Yes, Your Honor. This violation, the factual basis for the violation, relates to contact arising out of the law.
Things heat up as the defense challenges the violation claims, arguing that a simple email couldn't breach the order. The judge reminds both sides that the issue isn't communication, it's persistence. What started as a plea for clarity is now a battle over boundaries. You can feel the tension rising as each side digs in, trying to shape the story in their favor.
Lawsuit I just referenced, where I was counsel for her, Ms. Fazio, and I'm laying the factual foundation for why there is to be no contact directly with Ms. Fazio in that lawsuit.
Insofar you're laying it in that your argument's going to be, well, that contact should flow through you as the attorney.
Yes.
All right. Response, Mr. Cooper Keel.
My response is that the Michigan Court Rules, Chapter 7, Section 2 for the appeals court says that until an attorney files an appearance in that case, they are not representing the client. So for that to be relevant, he would have to be representing her in that case, because I think what they're getting at is that I served a copy of a motion from an appeal where she was not represented, not this other case he's asking about. So I don't see the relevance of the other case.
Okay. And response on wrong case argument, Mr. Hangeveld.
Yes, Your Honor. I was always the attorney for Ms. Fazio in her capacity as it relates to the lawsuit out of which the appeal arises. There was a motion for reconsideration filed. Whether it's my strategy or not to respond either to claim for interlocutory appeal or to not respond to a motion for reconsideration because it's not required to be responded to or not allowed to be responded to under the court rules. All of that doesn't obviate or vitiate my appearance on behalf of Ms. Fazio, my representation of Ms. Fazio. If that were the case, then you could make contact directly with a party and when they were represented by counsel. Clearly, that's not what the appearance rules require or provide for. In other words, I'm the attorney for Ms. Fazio. Mr. Cooper Keel knows that, and whether or not we chose to file an appearance in the Court of Appeals for an interlocutory appeal or not is not relevant.
Okay.
DPO.
Well, and I would tend to agree with your argument there, Mr. Hangeveld, and that typically when a person has, what I'm going to call as actual notice, that is, they know that an attorney represents another person, they are generally precluded from contacting that other person directly. And the forum, that is, whether it's the Court of Appeals or the District Court or the Allegan Circuit Court or the Kent Circuit Court, is not the controlling factor there. It's the representation itself. I'll overrule the objection and allow the response.
All right. So the question again, Ms. Fazio, was, were you represented by counsel in the lawsuit that Mr. Cooper Keel filed against you in Allegan County?
Yes, I was. You
Who
were
was your counsel?
You were in Price Hunteville.
Okay. And as it relates to the claims against you in that lawsuit, what was the outcome?
I should say Plunkett County. I apologize.
Okay.
What was the outcome? The outcome of the underlying case in the state court was dismissed.
Okay. And then it was subsequently taken up in an interlocutory appeal?
That's my understanding, is that it was taken up in an interlocutory appeal. That's correct.
Okay. And what is your understanding of the outcome of that interlocutory appeal?
It was denied.
And after it was denied, and again, I'm going to show you momentarily your some exhibits, but after it was denied, the interlocutory appeal was denied, do you know whether Mr. Cooper Keel filed anything further to address that denial?
Yeah, I believe he filed, and I can't remember what the document was called, but he filed a late document, a motion for reconsideration, I believe is what it was entitled, or something to that effect,
Okay.
With the Court of Appeals.
Your Honor, I can either put it up on the screen if you'll allow me to share my screen, or I can just reference it. These are just the exhibits to the PPO motion. What would Your Honor prefer?
Why don't you go ahead and display it on the screen?
All right.
The judge steps in with authority, confirming representation and demanding order in the courtroom. The defense scrambles to stay composed, but frustration leaks through every word. The petitioner remains calm but visibly shaken. This moment shifts the tone. The judge makes it clear, this hearing will not spiral into chaos. From here on, every word matters.
Ms. Fazio, can you see what I have displayed on my screen?
Yes, I can.
Okay. And what is that? What is this that's displayed on the screen?
The motion to show cause for violating valid personal or foreign protection order.
Okay.
It's the one that I filed in this case.
Okay. And what is Exhibit A to that motion? And I have it up on the screen.
It would be the motion to reconsider denial of appeal for lack of merit that Mr. Cooper Keel filed with the Court of Appeals.
And is there any particular part of the motion to reconsider that you consider to be significant or relevant to the PPO violation?
Well, I mean, initially I felt like it was a violation of the PPO because it was sent directly to me, as opposed to being sent to you as my counsel. You appeared on the Court of Appeals Register of Actions as my counsel from the moment there was a Court of Appeals action opened. Mr. Cooper Keel had to actually add me as a party on the MyFile case for the Court of Appeals so that he could independently email this to me as opposed to sending it just through the MyFile system, which would have automatically copied you and did copy you and all of their counsel of record at the time. So I felt like the initiation of contact was both a violation of the PPO, and if you look at the content of the motion itself, it's quite inflammatory and violent. I look forward to whatever Trump does to the judiciary at paragraph 6, and I hope it involves the public executions. He's recently talked about French Revolution style. I know of 3 little punks. I think the next one, paragraph 7, I know of 3 little punks. I don't know. Yeah. That pretend they're trash lawyers breaking into my house lacks merit for them to explain. I eventually met the appellees. That's me, I guess. And of course, they are also pathetic people. The same people would be dumb enough to concoct such a scheme against me. Same dumb ones that get caught. Same dumb mentality of judiciary to pretend this appeal lacks merit. I mean, this is just sort of, calls the court pussies. I mean, it just sort of is kind of the similar tone as all the emails that I received from Mr. Cooper Keel.
Okay. And then you mentioned this already, but let's go to Exhibit B. What is Exhibit B, and what was the purpose of you including it?
Exhibit B is the Court of Appeals Register of Actions that shows that you are my counsel of record and have been. Yeah,
and I point to page 9 of that, I guess 9 of the motion, which would include Exhibit B. Indicating that I'm the attorney for both Ms. Fazio and her law firm, Price Underley. And then what is Exhibit C?
This is the MyFile receipt that Mr. Cooper Keel, that shows that Mr. Cooper Keel added me as an individual for e-service, and I guess no one else. So he wasn't satisfied with the attorneys of record, so he made sure he added me so that I would receive it.
And finally, what is Exhibit D?
Exhibit D is the email I received on June 10 from MyFile indicating that I was added to that case so that I would, and then attaching a link to that, I guess, motion for reconsideration that was filed with the Court of Appeals.
And for the record, that's June 10th of 2024 at 11:50 p.m., correct?
Yeah, correct. Most of his emails come in late at night, early in the morning.
Since this contact on June 10th, 2024, has Mr. Cooper Keel attempted or had contact with you thereafter?
Yeah, he attempted again on December, let me look here. I think it was December 2nd. I received an email from MyFile that stated that was, well, it's from MyFile, but it stated that Devin Cooper Keel was attempting to add himself as a connection to my MyFile account, which, had I allowed it, would have granted him access to all of my cases, all of my filings, and all of the cases that are using MyFile. And it would have given him access to my payment source, my credit card that's on file for the filing fees on the pleadings. And then on December 5th, I received an email from Debbie Brewer, who's an office manager in the old building I used to be in the trust building at 40 Pearl, indicating that Mr. Cooper Keel was attempting to send me a package to my attention at my old professional address. I had moved out of that building in 2020, but I just instructed her to return it to sender.
Right. Your Honor, I don't have any further questions at this time. Thank you.
Very well. Mr. Cooper Keel, do you have any questions for Ms. Fazio?
Yes. In Exhibit B, the Register of Action, I didn't see a date as to when the attorney Hangeveld was added as counsel. Is there any date on Exhibit B for when that list was produced?
That list was produced on June 11. I printed that off the day after I received the 11 something p.m. email from you. So it was June 11 that I printed it. I don't know on the Register of Actions if he was ever added. I think it just comes up from the state court as every attorney that's of record in the state court.
Okay, so that was a Register of Actions from the state court, not the Court of Appeals.
No,
correct?
that was just, nope, that's wrong. That was a Register of Actions from the Court of Appeals.
Can your attorney put it back on the screen and show it to me? Because it's the first time I've ever seen that.
DOA docket number at the top there on Exhibit B. That is the Court of Appeals Register of Actions from June 11 of 2024.
And when was the date that Mr. Hangeveld filed an appearance for you in that case?
I don't know.
What? I'm sorry, I didn't hear you.
I don't know.
And she did not know.
Okay. So you don't even know when you filed an appearance in this case?
I didn't file an appearance in this case. I'm a party, not a lawyer.
I mean your attorney, Jeffrey Hangeveld, you don't know when he filed an appearance in that Court of Appeals case?
That was my testimony.
Well, your PPO complaint says that he did file an appearance for you in that case, doesn't it?
Asked and answered, Your Honor.
I don't know what, I don't have it in front of me.
Hang on, let me rule on that objection, Ms. Fazio. Response on asked and answered, Mr. Cooper Keel.
I don't recall when it's been asked and answered. In fact, they claimed that he represented her, but
Yeah, he elicited testimony that he was the attorney. Are you asking something different then?
yes, I'm asking when did he file an appearance?
I already answered.
And she
You're
already,
referring to the appeal in this matter.
All right,
that- I don't want to put words in your mouth. You might
she doesn't know. She said she doesn't know when.
Okay.
So I guess that's I don't object or want to push against the objection. They're right. Asked and answered.
You may continue, Mr. Cooper Keel. The objection sustained.
Isn't it true that in your PPO complaint you claimed that he had filed an appearance in the Court of Appeals?
I'd have to see the complaint. I don't know. He appeared for me from the moment there was a Court of Appeals action.
For an attorney to appear for somebody, don't they have to file an appearance?
she asks for a legal conclusion.
All I know is that he appeared as counsel of record from the moment I saw the docket at the Court of Appeals.
How did you get the Register of Actions from the Court of Appeals?
It's available online.
Where at online?
I'd have to go look up the URL. I don't know.
Okay. I'm just wondering where that came from because I don't know how to get one for the Court of Appeals.
Is there a question?
Where did you get how do you get the list of Register of Actions?
Your Honor, she already testified. Objection asked and answered. She already testified. She does not know. She would have to look up the URL, which is not on Exhibit B.
Okay, and I did hear that asked and answered before, and she said she doesn't know as we sit here today, so you may move on to your next question, Mr. Cooper Keel.
So how do we even know that Register of Actions came from the Court of Appeals?
Because I obtained it from the Court of Appeals website on June 11 of 2024.
Do you think it's possible maybe it's showing the lower court Register of Actions rather than the one for the Court of Appeals?
No.
So you said your first contact with me came in 2022 when you sent a cease and desist letter on behalf of your client, right?
Correct.
And I responded to that email asking you, how do you think I am harassing or trespassing on your client's property? Because wouldn't I have to first be doing something to cease and desist it, correct?
I don't recall every word of that email. Do you have a copy of it?
Yes, I do.
Okay.
Would you like to adjourn for...
No.
No. Okay. And isn't it true you didn't respond with anything to my request for you to describe how you think I've even been doing that to cease and desist it?
Objection relevance, Your Honor.
Okay. Response on the objection to relevance, Mr. Cooper Keel.
Well, what she said about her email contact with me in 2022 is completely false in her own direct testimony. She said I sent threatening emails then. Now she doesn't remember what even was sent.
Your Honor, may I respond?
You may.
Well, while it's accurate that I did ask a question about, I guess, the foundation for the PPO, or at least my intent to lay a foundation for the PPO, and we're not here to relitigate whether the PPO was properly issued, and we're not here to relitigate the case against that Mr. Cooper Keel had filed against Ms. Fazio's client in that lawsuit. So that's why I object on relevance.
Okay. Well, the question of relevance is with regard to are the prior emails and the content of those emails relevant? I think their existence is relevant because, after all, these violations would have come via an email notice of this register of actions. However, the content and the reasons they were utilized as the basis for the PPO are not relevant to today's hearing. I'll sustain the objection and ask that you move on to your next question, Mr. Cooper Keel.
Then in 2023, in your direct testimony just now, you claimed I said to you I was coming to your office. Is that correct?
Something to that effect, yeah.
Do you have any copy of any email saying something to that effect?
The emails that are the basis for the PPO that were received in January of 2023 from you were attached to the PPO application. I don't have it in front of me, but if you want to show it to me, I'm happy to talk about it.
So, isn't there no email that's been submitted with your PPO application where I said anything about coming to your office?
I don't think that's true.
Your Honor, I'd ask you to. Do you think it'd be fair? I guess I shouldn't ask the judge. Do you think it'd be fair for the judge to take judicial notice of what you filed and that it doesn't contain anything about coming to your office?
No.
Response, Your Honor, to the request for judicial notice. That's not the purpose of judicial notice, because it would have Your Honor make some sort of judgment or analysis of what the content of the PPO email is, rather than a judicial notice, for example, an unobjectionable fact such as the date on a calendar or things like that.
Okay, and with regard to judicial notice, it's typically taken of facts or legal pleadings or something of that nature that's filed but not in dispute. Of course, the factual contents of all of those pleadings may or may not be in dispute at any given time, so they're typically not subject to judicial notice. So I'll deny the request for judicial notice at this time. I am able to consider it for evidentiary purposes. You may consider with your next question, Mr. Cooper Keel.
Okay. So the entire basis for this complaint of a PPO violation is that the state's automated email system from the Court of Appeals emailed you a copy of my motion to reconsider in a civil case against you. Is that correct?
No, that's not correct. The basis for the violation that I filed not only is the fact that you went out of your way to add me as a contact to a Court of Appeals action and make sure I received the document that you filed, which was not only untimely and unwarranted and apparently had no basis in law. But then the content of the document that you filed was additionally inflammatory, aggressive, inappropriate. I believe you were sanctioned by the Court of Appeals for even filing it. And then, of course, the continued harassment that's continuing that I received on December 2nd. I received additional harassment on December. I think that one called me, and pardon my language, Your Honor, because it's as appalling and disgusting to me as I'm sure it is to the court, but I believe that one referred to me as an old cunt, I think, I don't know, scores of times. And then the December 5th attempt to reach me in my office as well. The continuing violations are adding up, and I desire no contact. You've been ordered to have no contact, and that's why I filed the motion that I filed for violation.
Now, I thought you said whatever was sent to your office address on December 2nd that they contacted you December 5th about, your office contacted you, right? It wasn't me that called you to tell you something arrived?
There were two separate contacts. There was one on December 2nd where you tried to add yourself as a connection, which would have allowed you to make filings on my behalf and access my payment source in my file. That was December 2nd. December 5th, I was contacted by an individual who worked in my old building saying that you were attempting to deliver something to my old building. So those were two separate instances.
That I was personally attempting to deliver something, or the mail was trying to deliver something?
I wasn't there. I don't know who was there standing in her office, and I just said, return it. I don't want it.
Okay. So how do you know whatever was in it? Because you just said whatever was in it called you an old cunt, but you said you told them to just return it. You don't want it.
That document was filed with the Court of Appeals as well, and I don't know what was in the December 5th package. I only know about the December 2nd attempt to add yourself to my file account. I reached out to my counsel, and I think at that point in time he said, oh, there's even more filings in this Court of Appeals, and this is what they are. And that's when I got to see that you apparently had filed the offensive pleading in court. And I don't know if that's why the attempt was made on December 2nd. It was around the same date, though.
When did you discover about what you refer to as the offensive filing in court related to this December 2nd or December 5th event?
I don't understand your question.
When did you discover this offensive document you just referenced?
I believe my counsel provided it to me around that same day, around December 2nd. I don't know, it might have been December 5th. It was around the same time where I reached out to counsel and said, hey, he's still attempting to contact me, he's attempting to become basically my legal assistant by becoming my connected user on my file. And so when I reached out to my counsel, and that's when he said, well, this just showed up at our office, and it's more of the same vitriol that has been filed in the Court of Appeals and what's been contained in the emails.
And so what was the title of the document?
I don't remember.
Do you remember what type of document it was at all?
It was a pleading filed in the Court of Appeals.
What type of pleading?
I said, one that's out of time, I don't know.
So you're a lawyer and you're a party to this appeal, right?
I don't know. Here's the thing. The Court of Appeals has ruled. I don't believe there's any open matter before the Court of Appeals. I think there's some filings that you're making that are attempting to file late things in the Court of Appeals for the purpose of name calling, and for no other purpose other than that, in my estimation. And that's what you're filing. Does it have any legal basis or merit, or is it the kind of thing that normal attorneys would file? No, it is not the kind of thing that attorneys would normally file.
So you don't know what type of thing it was, and you're an attorney. Is that what you said? Some type of motion, but you don't know what type of thing it is that was filed.
Asked and answered, and now it's being argumentative.
Okay, yeah, you're right. I find it incredulous that an attorney, a licensed attorney...
Right. Well, you can save it for your closing argument, Mr. Cooper-Keel, but for the moment, I'll abstain the objection, and you may move on to your next question.
Okay. Isn't it a bit over the top to claim when somebody tries to add you as an email recipient to M-File, they're trying to take over your whole business or something?
No.
Argumentative.
I'll allow the answer because it was responded to. You may ask your next question, Mr. Cooper-Keel.
Okay. What was the context of me using the phrase "old cunt" in the document you're aware of that was filed in the Court of Appeals in this December?
I don't know. The thing was gibberish and very difficult to understand.
What section of the document was it in?
First couple pages.
Was there a title to the section? You don't know if there was a title to the section?
No, if you want to show it to me, I'm happy to take a look at it, but I didn't commit it to memory.
Did you read the entire document?
Yeah, I think I read most of it. Yeah.
How many pages was it?
It was long. I don't remember exactly how many. If you want to show it to me, I can count for you.
Isn't it true? Does it recall your memory that that phrase was only used in the explanation of lateness section of it?
Radio.
What?
I have no idea.
We're not even here based on you not liking my appeal that was filed in December of this year, correct?
We're here on a PPO violation.
From when?
June.
So then, would you agree that we're not here for anything about you were sent an appeal in December?
We're here on PPO violation, and answer is my answer.
It's a yes or no question. Are we here for something from December or aren't we?
Asked and answered. She already answered that we're here for a PPO violation.
When was the PPO violation again? I guess, yeah, go ahead. I don't object to his objection.
Okay, then I'll sustain the objection. You may move on to your next question.
When was the PPO violation?
Well, there was one in June of 2024, and there were two more in December of 2024.
Have you filed a complaint about the ones in December?
Not yet. I was hoping for judicial economy we could handle it here today, but if not, I'll have to file a separate one.
Don't you think the Court of Appeals would be the more appropriate venue to file a complaint about my June motion
No,
than this court?
no.
Why didn't you file anything in the Court of Appeals complaining about it?
Your Honor, this calls for, it calls for,
Now the evidence comes to light. Exhibits A through D are shown, a series of emails that tell their own chilling story. Each message adds pressure to the room as the timeline of contact becomes undeniable. The petitioner's voice trembles as she describes the emotional toll, while the defense tries to minimize impact. The atmosphere turns heavy. This is the turning point.
attorney-client privilege or, attorney-client privilege, as to why we didn't do something, strategy, etc.
Response on privilege, Mr. Cooper-Keel.
I didn't ask her about something she said to her lawyer or anything. In fact, she wasn't even represented at that time in the Court of Appeals case. I'm just asking her why she didn't. Why in this case instead of the case it was actually filed in?
May I respond as to why it's still privilege, Your Honor?
Go ahead, Mr. Engelville.
The question was asked as to why Ms. Fazio didn't take up the issue that there was a violation of the PPO with the Court of Appeals. That calls for a strategy as to why she wouldn't have also addressed this issue in the Court of Appeals. To me, that's a privileged, confidential reasoning.
All right, I agree there could be portions of this that intrude on the attorney-client privilege. However, I haven't necessarily, I have heard from Ms. Fazio that she didn't file in the Court of Appeals. Is there any further statement as to why you made that decision that's non-privileged, Ms. Fazio?
I wouldn't have filed anything in the Court of Appeals. I wasn't counsel of record. Mr. Hangeveld was counsel of record in that matter.
Okay.
And I relied on his opinion.
Very good. Your next question, Mr. Cooper-Keel?
Are you aware of the stalking statute, which the PPO is based on?
I'm aware of it, yes.
Are you aware of the section that says service of legal process or constitutionally protected activity, like legal process, cannot be a basis for a contact in this context?
You'd have to show me the statute.
MCL 750.3, no,
You'd have to show it.
411H.
You'd have to show it to me.
Okay. Okay. Your Honor, I don't know how to share my screen.
Well, and I think you're trying to quote directly from a statute, Mr. Cooper-Keel, which normally, is not going to be a proper basis if it calls for a legal conclusion. Why don't you cut to the chase here and just ask the question that you're driving at?
Well, maybe the petitioner would like to take her complaint back if she saw that her getting served with legal documents is not a violation of any law.
Okay, I think that's the argument that you're making, that it didn't violate the law. I think you're certainly free to make that during closing argument. I don't know that, Ms. Fazio, do you wish to withdraw your alleged violation at this time?
No.
Okay, then you may move on to your next question, Mr. Cooper-Keel.
So, you said the basis for now is that a person can't make contact with another party in a lawsuit if they're represented by an attorney. Is that right?
Your Honor, that's mischaracterization, misstates prior testimony, misstates our position in the PPO violation.
All right, response to the mischaracterization of prior testimony, Mr. Cooper-Keel.
Well, I guess I just asked them to clarify it because that's what I wrote down in my notes, and I was just going based off what I heard.
All right. Well, and what I guess I heard, of course, is that they're not really straying from the basis is that you had contact directly with Ms. Fazio via that electronic notification system in the Court of Appeals, and that was not necessary per the statute that you just stated, because at the time she was represented, that is by Mr. Hengeveld, in that matter, and the notification would have flowed properly through him. I think that's the testimony that you're driving at.
Yes.
Okay, and now I've forgotten what your question was, however.
Well, I mean, I guess it seems like they are under the impression no party to any case can make contact with another adverse party that is represented. Is that?
Well, and I will say that does misstate, although not an entirely wrong statement of the law. It does misstate the prior testimony, because we're not here, on a, really be an ethical violation when an attorney contacts a represented party, but rather we're here on a separate matter, protective order violation. So I'll sustain the misrepresents objection insofar that you're stating it that way, Mr. Cooper-Keel, and ask you to rephrase the question.
Isn't it true that only an attorney is bound by an ethical rule not to contact an adverse party if they're represented by an attorney?
Directed at the court or Ms. Fazio?
Ms. Fazio.
Calls for a legal conclusion. If Ms. Fazio, I don't know if you want her to answer, I'm sure she can, but calls for a legal conclusion.
Yeah, I would tend to agree with that. However, Ms. Fazio, if you wish, if you have a response, you may respond.
I don't have a response.
Okay, very well. You may continue, Mr. Cooper-Keel.
Do you know of an ethical rule for, and I can't remember how I just phrased it, but I guess could I get her qualified as an expert witness so she could? She is an attorney. I guess I'd move to qualify her as an expert witness.
You can't qualify a fact witness as an expert witness, because the expert, of course, serves at the service of the court, not as an advocate for any particular party. So there is a prohibition in general on a party serving as their own expert witness. So I'll deny the request to qualify her at this time.
All right. I don't have any further questions, Ms. Fazio.
Very good. Thank you. Any follow-ups, Mr. Engeveld?
I don't have any further follow-ups. Thank you.
Very good. Then, Ms. Fazio, you may step down from the witness stand. Any additional witnesses or proofs, Mr. Engeveld?
I have no additional witnesses or proofs at this time.
Any witnesses or proofs to present Mr. Cooper Keel?
Yes, I'd like to call Mr. Hengeveld.
I don't think that's permissible. That I'm a lawyer in the case. I'm not a witness, and I don't have counsel myself.
Certainly true that you can't represent yourself. What would be your basis for calling Mr. Hengeveld, Mr. Cooper Keel?
Well, Ms. Fazio doesn't know when, if ever, he filed an appearance in the Court of Appeals in that case. And that is the basis for their claim that I contacted somebody who's represented. So, supposedly, Mr. Hengeveld's the attorney who filed it. I'd like to question him about his appearance in that case.
Your Honor, I can respond to that.
You can go ahead and respond, Mr. Engeveld.
We're not here as a basis as to whether or not I actually was filing an appearance in the Court of Appeals, because the PPO doesn't distinguish between what type of contact. It says no contact. And so when Mr. Cooper Keel makes contact by way of initiation of service of a motion for reconsideration, that's contact via the MyFile network. And that's the violation that we're here on today. It doesn't matter if I was filing an appearance with the Court of Appeals or not. Mr. Cooper Keel didn't have any, or to the extent that he needed to serve that document, he knew to serve it on me as her counsel and not directly on Ms. Fazio. So that's why the appearance in the Court of Appeals is not necessary, not a necessary issue to decide, for this court to decide.
Okay, and you disagree, Mr. Cooper Keel?
Well, yes, Your Honor. And I think in my brief for asking for a dismissal of this, I pointed out the court rule, MCR 7.26 something, that says until in a case in the Court of Appeals, an attorney files an appearance, that attorney is not considered representing the person in that case. And on top of that, they are saying that he did file an appearance, except the witness can't remember when, and I think they're lying. So if Mr. Hengeveld, who himself would have been the person to file that appearance, wants to say he did, then fine, let's hear when it was. Otherwise, I don't think this whole me serving her something in a case where she didn't have an attorney is even relevant to some kind of PPO violation.
And the basis for making that argument, Mr. Cooper Keel, is if Ms. Fazio is the respondent in the Court of Appeals case where you're the petitioner, but isn't represented by an attorney, then the only way to achieve service on her is directly by you listing her information, as it were. You did, and then you would be accepted under the exception for stalking for the service of legal process. You're not serving her as an attorney in that case. You're serving her as the actual respondent in the case, not represented by an attorney, because you don't have notice in that specific case. You may have it in the underlying case, but not in the appeals case, that she is represented by an attorney. Did I characterize that correctly?
That is exactly it, Your Honor.
All right, Mr. Hengeveld, let me hear your response on that specific issue.
Yes, Your Honor. On that specific issue, Mr. Cooper Keel has actual notice that I am the lawyer for Ms. Fazio and her firm. And regardless of whether I have a notice on file in the Court of Appeals, the Court of Appeals website, Court of Appeals docket on its website still reflects me as counsel for Ms. Fazio and Bryce Enderle. So Mr. Cooper Keel had no reason not to just serve me, or if there was no appearance by myself or Ms. Fazio in that case, then he could proceed as if she never appeared in that interlocutory appeal. So if you don't appear in the interlocutory appeal, you don't have to be served.
Okay, and you're saying part of that is based on the very nature of an interlocutory appeal. In that, of course, it's up to the the trial court whether or not it stays pending the interlocutory appeal or doesn't, and the interlocutory appeal goes on and does its own thing with appearances of lawyers. But all of the filings, in the interlocutory appeal would also be filed with the trial counsel of record. Is that right?
I believe that's accurate, Your Honor. Yes.
Okay.
Yeah.
And that's what certainly at least reflected, as far as we can tell here, in this, what I'm going to refer to as the printout from the Court of Appeals.
Right.
Okay. All right. Well, and I will note for the record, I mean, of course, in any case, an attorney is required to file an appearance. However, I will also note that those can be filed a variety of ways. Typically, courts require them to be in writing, although an attorney can appear orally on the record and argue a case as it is. And in interlocutory and other types of appeals, there are filings required both in the trial court and in the Court of Appeals. And typically, the information, particularly in an interlocutory appeal, is going to be relevant to both trial attorneys and the appellate attorneys, who may or may not be the same individuals in any given case. So, therefore, the filings are typically delivered to each attorney of record, be it in the trial court or the Court of Appeals. I'll overrule the objection and not allow the calling of Mr. Hengevelde's witness as to the date of his filing of his appearance in the Court of Appeals at this time.
And I'll just skip calling him.
Okay. Any additional witnesses or proofs?
I'll call myself as witness.
Very well. If you'd raise your right hand. You solemnly swear or affirm that your testimony today will be the truth and nothing but the truth.
Yes.
Very well. Go ahead and make your testimony, Mr. Cooper-Keel.
Well, okay. So, she really misrepresented a lot of stuff that could, to some extent, be material. Like, she said, the petitioner said her first contact with me was in 2022 when she sent me a cease and desist letter. That's true. And then I sent back to her, cease and desist what? Like I hadn't been doing anything, which she asked me to cease and desist, and she never answered that. And then I didn't send anything threatening to her. In fact, I think I told her, when she didn't respond and describe to me what she even means, I told her, I think I'm going to just take this to be another BS letter people send to me and stop sending me stuff. And then she was representing her client in that case was my aunt that she was sending me a cease and desist letter for that my mom and other aunt were suing to split up a piece of property. And petitioner was the attorney representing the other aunt. No good. And she kept bringing me up in their case saying I was harassing her and trespassing. Like she said in her cease and desist, but she couldn't tell me how she thought anything like that was happening. I hadn't even talked to that aunt for years. And so I sent her a cease and desist letter myself on January 3rd, 2023. And I told her to stop defaming me in a case I'm not even in and go correct your statements about me. And she never responded to that one either. And then she emailed me on or about January 16th, 2023, asking me to dismiss a different case that I was a party in that she was also an attorney to. And that was when I told her, no, I would not dismiss that case. And that I intended to sue her for her defamation of me, that I'd been asking her to cease and desist. And that was the time I used the phrase old cunt that she complains of. And yes, the thing that was sent to her on or about December 2nd was an appeal from a civil case, which I filed after I found out she had then, after this January 16th thing, taken part in a conspiracy to break into my home on or about March 8th to spy on me. She got sued.
The focus shifts to the continued harassment and recent contact attempts. The judge's patience thins as the same explanations repeat. The courtroom feels like it's holding its breath. Every statement now adds weight to the outcome. The defense senses the tide turning, but the petitioner's consistency keeps the credibility strong. The truth starts crystallizing.
For that, because I found out she did that. And yes, that was dismissed, which I think was an erroneous dismissal. So I filed an appeal in that case, which is what was sent to her December 2nd, which is not what was even really the subject of bringing me here today for. I had filed earlier, immediately upon her being dismissed from that case, an interlocutory appeal, which the court declined to hear. That's what the motion to reconsider was from, June 10th or whenever it was. And I think actually she complained of not just being served that, which the appeals court rules don't just say you have to serve the party a copy of it, but they say if possible, like if they're a registered user to the MI file system, which the petitioner is as an attorney, you're supposed to serve it to them electronically through the MI file system. So I tried to put, and it was 11:50 at night, and I think it was the deadline for that at midnight. So yeah, I was hustling to try and get in as many of the emails in as the MI file thing as I could. That's why she got that email from the state of Michigan's website. And it wasn't like it was some illegitimate thing. I know tastefully she doesn't seem to like my motion to reconsider I filed. I actually think it was part of my legal strategy to file it as I did. And I waive privilege with that. Well, I wasn't represented, so I don't know if I have privilege for my legal strategy anyway. But my impression is the Constitution doesn't really exist. I don't think I'd be here today being summoned simply for a motion to reconsider a dismissal of appeal in a different court. To summon me for a PPO violation after the state requires me to serve her with it. The state's email system is the one who served her. And then on top of that, I'm going to get hit for a PPO violation. That is definitely entrapment, right? State makes me serve her a copy, then hits me with a PPO violation for serving a copy of a legal document in a court of appeals case. That's all this boils down to. And she didn't like the content. The contents are the Constitution, in my estimation, things doesn't really exist all that much. So it's basically the law of the jungle. And so I think I ended that brilliant document of mine. Basically, to sum it up, I was writing to a panel of 3 male judges who declined to hear the case. I thought it was an important Fourth Amendment, unconstitutional break into my home without a warrant that they gave them governmental immunity to do. I thought that was a pretty significant Fourth Amendment issue. But since the Constitution doesn't exist and it's just based on ego, maybe if I call these 3 judges pussies, which is, I think, something I call them, or to that effect, pardon my French, maybe if I stroke their ego the wrong way, maybe they'll at least pick it up and answer it. And then I think, so then I ended it and I said, maybe the majority female Supreme Court actually has a pair of balls because you guys are really copping out on doing your job. I thought it was a smart legal strategy. Might as well give it a try since the Fourth Amendment violation wasn't that big of a deal to them. I can see where, some people might find that distasteful, but that was my legal strategy. I'm supposed to be entitled to a legal strategy. And that was the only thing behind that. Like, I've never personally contacted her. She tried saying I said something about going to her office. Like, I have better things to do. I'm in my office right now, and unfortunately, I've been pulled out of another hearing that I was already in to join this one, and I missed. I'm not going to be able to file something I had to get filed before 5 o'clock now. So this is a huge. This is just lawfare. This is her legal strategy. This PPO complaint. It's not because she actually thinks there was some violation of the PPO. This is her legal strategy to try to throw off my ability to appeal cases which she's either a party to or an attorney in, right? She claims she didn't see, and she lies too. She is a pathological liar. At first she said she didn't even look at whatever I filed on December 2nd. She doesn't know what it was about. And then I questioned her, well, my attorney said he got a copy, and then I looked at it. She just is over the top making stuff up. Like, oh, he's trying to take over my MI file account. Like, the only time I tried adding her to the appeal I filed on or about December 2nd was while I was trying to file it and add the users from that case to it, and she was one of them. And that's what it was that was sent. I mailed it and I emailed it. I can't remember if I emailed it to her or her attorney from this case, because after what I've had to deal with this, I'm pretty sure I can't remember. You know, the problem is, especially like the way my objection to this case, there are so many hidden ways service or timing of a filing might not be okay. I wanted to make sure I was okay because I intend to have my appeal be timely and all those things, right? And so if I don't serve it to her, I'm at risk of it getting dismissed and them saying some fancy thing like, well, her attorney hadn't filed an appearance in this case, so your serving him doesn't count. I'm at risk of that too. I'm at risk of PPO violation if I follow the Court of Appeals. Like it's entrapment. That's what it boils down to. And I know that's argumentative, and I'm just giving witness testimony right now as to my state of mind and what this is even about. Like, this is about a motion to reconsider that she didn't like. And it was the state itself who sent it to her, who required me to put her email in there to send it to them. I think they're lying about Mr. Hengeveld filing an appearance in the Court of Appeals before that motion to reconsider was sent, because all I had filed was an application for interlocutory appeal, and there wasn't really anything they would have had to answer at that point, you know, unless they're going to take up the thing. And I don't recall. I definitely, at the time I sent that, I had not seen anything. In fact, I still don't believe, based on their questioning and how flimsy they were, like, well, we don't know if it did now, and I don't think they had an appearance in the Court of Appeals case. I never saw one, that's for sure. So at the time I did it, my mentality was, here's what the court rules say. I have to serve the person directly as far as mail, by first-class mail, I think is all it is, or by their email. And I did it by their email.
You ready to be cross-examined by Mr. Angeveld yet, Mr. Kuberkeel?
Yeah, I'm ready.
All right, Mr. Angeveld, any cross-examination?
I have no cross-examination.
Very well. And I don't think I have any additional questions at this time, Mr. Kuberkeel, so you may step down from the witness stand. Do you have any additional?
I just remembered.
Go ahead.
I just remembered one other thing I wanted to add. The petitioner claims I used the phrase "old cunt" in the thing I filed to the Court of Appeals, which was an application for appeal. And I'm required to put, if it's a late appeal, an application for late appeal, which is what it was, an explanation for the lateness. And I had to mention about this case and this hearing that I'm under constant lawfare from her through this case for what I filed in the other thing. And the only basis for this thing being in place is that I used that phrase, "old cunt," in the email I sent in January 2023, which she submitted as the basis for this appeal. He called me a bad name in an email she contacted me with first. So I had to explain my lateness. And so I told the Court of Appeals in that application for late appeal about this hearing, about this case, about how it has added a lot of extra expense and tax to my time and efforts and everything. And so that's contributed to the lateness. And it's in fact the petitioner who contributed to the lateness of that appeal, which is another reason I think they should overlook the lateness of it. So that's the only reason the phrase was used in it. It wasn't like I was calling her that name. I put it in quotations in reference to how this PPO began, is that I sent her an email after she emailed me first and called her an old cunt. So it was inaccurate, and I can tell how evasive petitioner was. Oh, I don't remember which section I read that in, all this. Like, she's a lawyer. She knows what I said it for. She knows it was quoted in reference to this PPO, and that it wasn't me giving her a fresh round of name calling. It was me trying to excuse the lateness. and giving context to the Court of Appeals about what's going on here. So that's also something she lied about just now. Anyway, I'm done. I just wanted to clear that up.
All right, thank you. Any cross based on that last bit of testimony, Mr. Engel?
No, Your Honor, no cross.
Very good. Then thank you. You may step down, Mr. Cooper Keel. Any additional witnesses or evidence, Mr. Cooper Keel?
No, sir.
All right. I think I've already heard the majority of your closing argument was kind of intertwined with your testimony there, Mr. Cooper Keel. So I'm going to turn to Mr. Hengeveld since we are running a little low on time this afternoon. I'm not certain if I'll be able to rule on the record or not, but in any case, Mr. Hengeveld, briefly, your closing argument.
Yeah, I'll be very brief considering the hour. And Your Honor has a firm grasp, I believe, of the facts as presented here, which to me show clearly that Mr. Cooper Keel intentionally contacted Ms. Fazio by way of adding her specifically to the MyFile system so that she would be specifically contacted by with his motion for reconsideration. We've shown you that contact is Exhibit D to the PPO motion to show cause, that email on June 10th of 2024. And Ms. Fazio's reason for filing this violation is because the PPO says no contact. Mr. Cooper Keel knew that I was her attorney, and if Mr. Cooper Keel was concerned about service of this motion for reconsideration, he could have added me, or he could have emailed me, or could have served me. Again, the Court of Appeals isn't requiring a motion for reconsideration, to my knowledge, be served on a party who has not yet appeared in the appeal anyways, which I think is what Mr. Cooper Keel said as part of his testimony on his own behalf. So for those reasons, Your Honor, that it is a clear violation in writing, we would ask that you find the PPO to be violated.
Okay, well, the matter before the court this afternoon is the question. Anything to add for that you didn't already argue, Mr. Cooper Keel, during your last statement?
Yes, Judge. I'd just like to say, I mean, their argument voiced basically just now was that I could have filed his appearance for him and then served him.
Well, you could have served him as the attorney, and for that matter, you could have added him into the MyFile system, assuming he's got a profile on there, if you'd been worried that, she wasn't going to get adequate notice of your interlocutory appeal. So I think that's what I took the argument as. Not that you'd have to appear for him, but rather you already know he's on the case. Just like you made sure she got it, why not make sure he gets it?
Well, I've got a lot of responsibilities, right? I got a lot of things to do myself. It's not my responsibility to make sure her attorney, who has not even filed an appearance, gets a document related to it. I am required to serve any documents that I file to an appeals case. That's the other thing he said. He said he's not even sure I had to serve the party with motion to reconsider. I don't have the court rules right in front of me at the moment, but I'm sure if anytime a motion to reconsider is filed, you are required to serve the other parties a copy of that. And I could
hear what you're saying. This was a motion to reconsider an interlocutory appeal, correct?
That's correct.
Okay.
And I don't know. I'm not a lawyer. Is the other thing, right? To act like I knew all these ins and outs, and I just tried to use them as an excuse to contact the petitioner. Like, I don't even know this person. I have absolutely no reason to have any contact with her. All my contact with her, in fact, have come from her contacting me. She emailed me in 2022. She was out defaming me leading up to me giving her a cease and desist in 2023. Then she contacted me again January 16th of 2023 asking me to dismiss a case. And that's when I told her what I thought of her. And the fact that she then participated in a break-in in my home and got sued for it, and that I appealed that, me appealing, I mean, this is like saying me filing an appeal in a civil case is a contact. That's basically what it boils down to. I lost my right to petition the government for a redress of my grievances about this person taking part in a break into my home because there's a PPO. And I don't think the PPO statute or anything to do with PPOs has any intention of being used as some cover to run for somebody that wants to get out of responsibility for a civil case filed against them. Well, the merits of the civil case really aren't the point. Point is, you're supposed to have the right to file a civil case against somebody. Really, there should be criminal charges with it too. But myself, as the victim of a break-in, for what they're asking you to take away my right to my most basic right, First Amendment right to petition the government for redress of my grievance. That's basically what this boils down to. Don't let him appeal us. He can't appeal us if he can't serve us. Make him afraid to serve us.
Chaos unfolds as cross-examination begins. The defendant's tone grows defiant, clashing with the judge's control. Interruptions fly, emotions boil, and for a moment, the courtroom becomes a storm of accusations. The judge fights to restore order, but this segment captures pure human volatility, anger, regret, and defiance colliding in one tense sequence.
So I'd ask you to just dismiss this, because that's the totality of what they're asking you. They don't like my appeal. They don't want me to be able to file it. And that's,
all right. Well, thank you, Mr. Cooper Keel. And, I will say, I don't like your style particularly either as I read through your pleadings and have in this case either. And I, tried to, in order to be objective, separate myself and say, Judge Rossi, stick to the legal issues under that, which is somewhat difficult when faced with vitriolic, as I described, language. And you're certainly not the first person to employ some vitriolic language in an effort and a part of their legal strategy. However, you do it pretty consistently and throughout your pleadings and throughout your other correspondence. After all, we got here, and not solely because of legal pleadings, but because of, additional correspondence, although connected to a legal case, that contained that sort of vitriol and language. And, the question before the court today is whether or not you're adding of Ms. Fazio to the Court of Appeals my file list of people to be served with your interlocutory appeal in a Court of Appeals action, not in this PPO itself, but in a separate action, could be a violation of the PPO. And you are correct to say, Mr. Cooper Keel, that there's an exception, well known to the Personal Protective Order statute and also the stalking statute that allows the filing of legal process on another person. This commonly occurs, of course, in a divorce action where there's also a PPO, but nonetheless, the respondents do need to file legal documents that are relevant to the divorce. Now, typically, those get filed by an attorney and via the opposing party's counsel, unless you get the benefit of some filtration by counsel. In an ideal world, although it doesn't always happen that way, oftentimes one or the other parties in the divorce action will proceed pro se, that is, without an attorney, and you don't necessarily get that benefit of filtration. In your case, you're claiming here, gee, Judge, I'm not an attorney. I don't know the ins and outs of my file, and, I am an attorney and a judge, and I don't know the ins and outs of my file all that well either myself, but certainly I would know that if I added Ms. Fazio directly to the people to be served, she would get served. And on one hand, I could give some credibility to your argument, Mr. Cooper Keel, that, I was just doing what I needed to do. I was being a belt and suspenders litigant, as we call them. At least I did an evidence class where, I wanted to make sure that this document got where it had to be within the time limits required. And that's why I added Ms. Fazio. Or the other the argument that leads to a violation is one that I wanted Ms. Fazio to see this because, I said things in there about trash lawyers and the French Revolution execution, although I believe that was directed at the judiciary, that I wanted her to read, whether it be for, intimidation, just to make my point, whatever, to her. Added to that is at least some evidence that Ms. Fazio indicated around the same time there was some fiddling around with her MyFile account, attempting to access the permissions to the account, which obviously you wouldn't have the ability to do, nor would any person in their right mind give anyone else, except perhaps their legal assistant, and in that case, a very trusted legal assistant, the ability to make a filing in their name, and of course, utilizing their credit card information and things of that nature. That tends to prove that your intention here was not the intention A, belt and suspenders, good lawyer, but it rather was intention B. I want to make a point to you. And of course, that does violate the PPO. And I will find at this time that there is proof beyond a reasonable doubt that you did violate the PPO and find you in contempt of court at this time. All right. With regard to sentencing, of course, the court rules do provide I can sentence you up to 93 days in the Kent County Jail and or a fine of up to $400, which I believe goes to the Kent County Library Board last I heard in this type of case. So anything to state with regard to sentencing, Mr. Angeveld?
Your Honor, at this time, I don't have any statement on sentencing. Again, I defer to my client, though, if she would like to say something.
Very well, Mr. Fazio, you are in this matter as a party and a victim. It's your right to make a statement at sentencing. Go ahead and do so.
I don't have a whole lot to add, Your Honor. I just want the contact to stop. I want no additional emails, no additional service. If he wants to serve something, obviously can serve my counsel. There are no open matters for any client I have that involve Mr. Cooper Keel. He is not a party in any action I have. There is no reason to have any further contact. And my fear is he doesn't take no for an answer, so I would appreciate a sentence that would at least advise him to, or be instructive to no longer violate the PPO. That's all.
Very well. Thank you, Ms. Fazio. Mr. Cooper Keel, what is your statement before imposed sentence?
Well, I would ask you to, I'd like a motion for a stay of sentencing pending appeal of the decision to find a violation.
I'll deny that at this time. Go ahead. Any other statement ahead of sentencing?
Well, the only thing I heard you say for what you found to be the PPO violation was that I was trying to access her MI file, get accepted as some acquaintance or something on there so I'd see her information. And she's claiming that happened December 2nd, and that's not even the subject of what we were here for today. So,
well, in terms of clarification, I didn't find that as the violation. I found that as additional evidence that the improper contact via the email, the MyFile account, was in fact a violation. So, but you may continue, Mr. Cooperkill.
Okay. Well, I would just ask you, Your Honor, that or advise, I did not intend to violate the PPO at all. I don't have any other kind of criminal anything going on. Very productive member of society. I need to leave right now to go pick my two sons up for their visitation with me for this weekend. I own a bail bonds agency. I do a lot of good work in the community. I volunteered for over 10 years coaching various youth sports teams, including my two sons' hockey teams, my daughter's soccer team. And I think I'm a very useful member for society to be out here. I don't think you need to send me any further message not to contact Ms. Fazio. Hopefully, I guess I would just cite this thing if there ever was an issue where they tried to say service on unappeared counsel isn't good enough for something like an appeal, because we do actually still have an application for appeal pending from the civil case I had against Fazio. I'm also not sure what to do on that in the future other than I'll just send her attorney that. I'll count him as forever appeared. I never had any contact with her. I don't know her personally. I've never met her in person other than I think maybe she was at the one hearing in this case when she asked to renew it. There's never been any violation other than this particular thing of this PPO. It was unintentional in my part. And I think you're really mistaken to find me in violation for, simply just making service of my motion to reconsider. And even though my motion to reconsider was not directed to her, maybe you think the language contained within it was a violation somehow. And if so, next time I'll just serve her lawyer, or I don't know what. I don't know how to write it better. All I can do is my best. And I'd ask for no jail time. I definitely don't need that. I've got a bunch of end-of-year stuff due for my business. And as you may or may not know, pretty much every circuit court updates their list of approved bail bonds agencies in December. So I was trying to get all of them done before today, just in case.
And I imagine it's harder to get those approved if you're sitting in the Kent County Jail at the time.
Yeah, that would be really bad. In fact, I haven't even gotten them sent out. And if you were going to give me any jail, I'd ask for I'd ask to wait for after Christmas so I can spend that with my family. But also, I mean, even probably more detrimental to my family than that would be right now. Like, I still don't have any of my stuff out for next year, and I have to get all that done. I was trying to get it all done before today, but I was also just on my way to the federal court because I got to sue the Kalamazoo County Sheriff's Auction for not allowing me to foreclose on 2 mortgages for a $100,000 bond forfeiture. So I just ask, if you feel like you need to, I don't think you do. I'll never serve her any papers again. I'll go straight to Mr. Hengeveld. And if you could not give me any jail time, whatever, if you think I should pay her or you a fine or whatever.
Mr. Cooper, I will say, given the length of this case and the amount of filings, the amount of the court time it has taken to process the case, I was tempted at the outset to send you to jail right over the Christmas holiday here just to teach you a lesson. However, I think you're smarter than that. I think the same thing can be accomplished here. I'm going to fine you $400, and I am going to suspend a 30-day sentence in the Kent County Jail, contingent on the fact that there be no more violations, emails, smoke signals, flag signals, carrier pigeons. I just simply don't care. I want there no communication to equal no communication, as if there is one of those force fields like you see in the movie surrounding Ms. Fazio with regard to you. Nothing should get through that. If there are legal proceedings you need to file, however you file them, just simply send them to Mr. Hengeveld. That would be proper. He'll advise you if he's not her attorney and representing her any longer in the matter, as he's entitled to, and then you can proceed from there. Like I say, I intend for this not to be violated so that Ms. Fazio can go forward in peace. I think you're smart enough to get that message without cooling your heels in the Kent County Jail and getting to meet potential future clients for your bond agency. But I hope you keep that in mind. You're going to have to go down there and get fingerprinted. However, part of the deal is when I find someone has violated, there's a mandatory fingerprinting. It'll be on a Saturday, I believe it's a morning at the Kent County Jail, when you go in and you just report into the Sheriff's Department. As I say to many people who do that, take a look around, though you've probably been there before, perhaps in your work in the bail bond industry, and be grateful that your stay is just for an hour and not overnight. That's how most people feel about any of our jails, even though, as jails go, the Kent County Jail is a very well-run institution. So, all that being said, thank you both for your advocacy. And like I say, this order does remain in place, as Mr. Engel pointed out, until next summer. And I do expect scrupulous obedience to it, because next time we won't have as lengthy drawn out proceedings as this. If I find a violation, I'll just simply say, gosh, Mr. Cooper Keel just never did get that message, and there's only one way to send it, and that's by cooling your heels in the jail. I don't think you want to do that, and I'm positive your kids don't want you to be doing that, so let's avoid that situation going forward.
The final moments are charged with exhaustion and emotion. The judge delivers a stern warning, making it clear that this pattern of behavior must end. Both parties look drained. It's the end of a draining confrontation that exposed far more than legal violations. As the gavel falls, one thing is certain: no one leaves this courtroom unchanged. Don't forget to like this video, subscribe to the channel, and we'll see you in the next one.